Mr. Murali.
Mr. Deputy Speaker, sir, I declare my interest as a lawyer in private practice dealing with, on occasions, traffic matters. I support the aim behind the bill, which is to deter irresponsible driving that may lead to harming of innocent lives and damage to property. I applaud the Ministry for obtaining feedback from public before presenting this bill for consideration in Parliament. In particular, in this bill, I support the calibration of punishment depending on the harm caused by the motorist in driving his vehicle dangerously or carelessly. Indeed, I note that the Supreme Court, in several recent decisions dealing with sentencing of motorists who are convicted for offences such as drink driving, dangerous driving, and careless driving, already apply an analytical framework which requires a consideration of the harm caused by the motorist as well as his culpability. I have a query on the proposal to provide for enhanced punishment for a serious offender who commits the offence of dangerous driving or careless driving. Serious offender is defined in the amendment bill as a person convicted for drink driving or alternatively convicted for refusing to give his breath sample. Under the proposed section 64 and 65, if the same person is convicted for dangerous driving or careless driving, he is subject to an extra punishment, which is in addition to the punishment for dangerous driving. So, for example, under the proposed section 64, subsection 2b, if hurt is caused where an offender is a serious offender, he is to be punished with a fine of not less than $2,000 and not more than $10,000, or to imprisonment for a term of not more than 12 months, or to both, in addition to the punishment for dangerous driving charge. On the face of it, there is a possibility that the serious offender may be punished twice. This is because, as mentioned before, in the current sentencing framework, the harm and culpability of a drink driver would be taken into consideration in relation to the sentence imposed on a drink driver under Section 67. So I do appreciate that this scenario would only be triggered if a person faces two charges, that of drink driving as well as that of dangerous driving. But we cannot have one analytical framework for sentencing in relation to drink driving if a person is charged singly, as opposed to another situation if he is charged for drink driving as well as dangerous driving. So I would welcome a clarification from the Honourable Minister as to what is the Ministry's expectation in relation to sentencing under Section 60, the proposed Section 64 and 65. The next query I have is in relation to the applicability of community sentencing options. I've previously spoken about the desirability to widen sentencing options during an adjournment motion in this House on the 11th of September 2017. I pointed out that then, for drink driving cases, the person on conviction would not be liable for community sentencing, but a motorist who was convicted for causing death by a negligent act under the Penal Code was imposed a community sentence of a short detention order. This was because the sentence for a drink driving offence under the Road Traffic Act was fixed in law, with a minimum mandatory sentence of a fine. In my respectful view, for traffic cases involving people behaving negligently or not realizing that they exceeded the alcohol limit, but who have caused low to medium levels of harm to life and property, community sentences may be a good option for them in terms of addressing the sentencing principles of deterrence as well as justice. Subsequently, in March 2018, this House passed amendments to the Criminal Procedure Code to expand the list of offences for which community sentences may be imposed. Now, under the amended Section 337, subsection 3 of the Criminal Procedure Code, a court may impose community work order, even if the offender is convicted of an offence for which a mandatory minimum sentence of a fine is prescribed by law. One example is the offence of drink driving. I would welcome the Honourable Minister's confirmation that this comports with the policy intent behind this amendment bill. I may be wrong, but one community sentencing option which does not appear to be open for offenders under the Road Traffic Act in relation to offences under Section 64, the proposed Section 64 and 65, is the short detention order. If a person is imposed with a short detention order, unlike an imprisonment, his conviction would not constitute as a registrable crime under the Registrations of Crime Act, Criminals Act. I would have thought that particularly for lower level of culpability acts leading to medium level harm, a short detention order should be considered as a suitable punishment so that the accused will not be delivered with a disproportionate crushing blow vis-à-vis his prospects in the future. I wonder why this option is not provided for in this bill. The next point I wish to make relates to the fact that the sentencing provision in Section 69 of the Road Traffic Act, which deals with the administration of preliminary breath tests, is being retained in its current form, even though the sentencing provisions for Section 67 are proposed to be enhanced. Currently, there is a parity of sentence under Section 67(1), which deals with drink driving, and under Section 69, subsection 4 of the Road Traffic Act, which deals with refusing to give a breath specimen for a preliminary breath test. In both situations, the first-timer would be liable to a conviction to a fine of not less than $1,000 and not more than $5,000, or to imprisonment for a term not exceeding 6 months. A repeat offender would similarly be liable for a fine of not less than $3,000 and not more than $10,000, and to imprisonment for a term not exceeding 12 months. In the bill, the sentencing provisions for Section 67, subsection 1 are proposed to be enhanced. However, the same is not proposed for Section 69, subsection 4 of the Road Traffic Act. I do appreciate that if a person does not provide a breath sample for a preliminary breath test, he may be arrested nonetheless and be required to submit a breath sample for a prescribed breathalyzer test at the police station. If he again refuses to provide a breath sample, he will be presumed to have committed the offence of drink driving and charged separately for the offence. However, given that there is currently an existing parity between the sentences provided for both provisions, and the aim of this bill is to deter motorists from irresponsible behaviour, I wonder what is the policy reason for not similarly proposing to amend the punishment for Section 69, subsection 4 of the Road Traffic Act. I also would like to ask if you have sufficiently leverage on advances made in technology. The prescribed breathalyzer test was introduced in 1996. It was contemplated then that the test had to be administered in the police station. The motorist has been transported to the police station for this. Now there are police-grade mobile prescribed breathalyzer machines readily available which provide very accurate readings and can be administered at the roadsides itself. There's also a potential for removing the need to administer preliminary breath tests. What we will then get is a reading of the alcohol level of the motorist at an earlier time, which probably would be a better gauge of what his alcohol level was at the time he was driving or was in charge of the vehicle. I also note that in France, drink drivers, especially repeat offenders, would be required to fit their cars with vehicle ignition breathalyzer or ignition interlock, which require them to take the test before they can start the car. They will also be required to blow on a second occasion at a random time to limit the chances of others blowing into the breathalyzer for them. I'll be grateful for an update from the Honourable Minister on this front. The final point I wish to make relates to the making of owners and operators of vehicles who cause death or injuries as a result of mechanical failure arising from negligent maintenance of their vehicles, especially heavy vehicles. I've spoken about this topic in this House recently. I appreciate that these amendments are being introduced by the Ministry of Home Affairs, and the focus is therefore on driver conduct. I would respectfully suggest that the Ministry of Transport take a look at the Road Traffic Act with a view to tighten the framework so that such owners are held responsible for death and injuries arising from their neglect. I also suggest that the Ministry consider making use of some safety measures. Let me read it again. Consider making some safety measures mandatory to protect other road users. And this is a call that was made by the Honourable Member Mr. Ang Hin Kee, as well as the Honourable Member Professor Walter Teixeira. It could consider measures taken overseas. For example, in the US, it's compulsory to install rear-view cameras. There are also discussions in several countries about making the installation of dash cams compulsory too. Dash cams can be a deterrent against the irresponsible driving too. the Honourable Minister mentioned about video footage being referred to the police for investigation. They are also a good source of evidence for investigation into RTA offences. Some dash cams have anti-collision sensors and could have made a difference, for example, in relation to the accident that the Honourable nominated Member of Parliament, Professor Lim San San, was involved in. And I'm so glad that she's none the worse for it. Notwithstanding my comments, I support the bill.